Okay, so we're now broadcasting these proceedings since we're conducting these proceedings on Zoom as required by Texas statute, the Office of Court Administration and the Supreme Court of Texas. All right, so this is in cause number 113873, Rod Coleman, on a hearing under 54.11 of the Texas Family Code, for this court to determine whether this person is transferred to the Texas Department of Criminal Justice to complete the remainder of their sentence, or to be or released into the community under supervision, or the TDC parole. The court will take judicial notice of the court's file and all of its contents. Specifically, on May 14th of 2021, this court found the respondent, Gerard Coleman, delinquent for the felony offenses of aggravated assault of deadly weapon on 2 counts. In a separate and distinct hearing, this court found a need for rehabilitation and committed the child to the Texas Juvenile Justice Department for a period of 10 years. Subsequently, this court received notice from the Texas Juvenile Justice Department requesting a hearing to determine whether this person should be transferred to TDC or paroled into the community. We are now here for that hearing. Mr. Coleman, I want to explain what's going on. The law states that when you have not paroled from the Texas Juvenile Justice Department, that you, if by request from TJJD, you are entitled to a hearing before me. I'm the sentencing court to determine whether you should be paroled or not. This is a hearing simply about whether, in my discretion, I feel it is more appropriate for you to be paroled or for you to be transferred to TDC to complete the remainder of your 10-year sentence. You do have certain rights at this hearing. You have the right to remain silent. You have the right to have an attorney. You have the right to cross-examine and confront adverse witnesses. You have the right to present evidence and argument, and you have the right, through your attorney, to examine any report that will be used at this hearing. Now, there are different factors I must consider at this hearing. I must consider the experiences and character of you before and after commitment to the Texas Juvenile Justice Department. I must consider the nature of the penal offense that you were found to have committed and the manner in which the offense was committed. I must consider the abilities of you to contribute to society. I must consider the protection of the victim of the offense or any member of the victim's family. I must consider the recommendations of the Texas Juvenile Justice Department, County Juvenile Board, local juvenile probation department, and the prosecuting attorney. I must also consider the best interests of you and any other factor relevant to the issue to be decided. At the conclusion of this hearing, I may order your return to the Texas Juvenile Justice Department or transfer to the custody of the Texas Department of Criminal Justice for the completion of your sentence. If I do return you to the custody of the Texas Juvenile Justice Department, I may return you with approval for release under supervision or without approval for the release under supervision. If I do not make a determination before your 19th birthday, you will be returned to the Texas Juvenile Justice Department for release under supervision. Because you are over 17 years old, if I do order you returned to TJJD and you are not in custody anywhere, I may order you detained in the adult jail of Tarrant County, and the Tarrant County Sheriff shall take custody of you under the court's order. There is no agreement in this matter, Mr. Coleman, so you do have a right to appeal. I will explain that right further to you in writing later and provide a written copy of the admonishments to your attorney to provide to you. Mr. Coleman, do you have any questions for me?
No, sir.
Okay. All right, let's go ahead and get started. Any matters before we start?
No, Judge.
No, Your Honor.
Okay. Opening statements.
I waive, Judge.
Ms. Herrick.
I'll waive, Your Honor.
All right, Mr. Sorrells, your first witness.
I would call Tammy Coy.
Ms. Coy, please raise your right hand. You solemnly swear the testimony you're about to give at this cause currently at trial, you will tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, thank you. Mr. Sorrells, please proceed.
Thank you. Ms. Coy, can you please advise the court, where do you work?
The Texas Juvenile Justice Department.
And what is your job title and some of your duties?
I am the TJJD/TDCJ liaison, and I oversee the Sentenced Offender Department, and we process sentenced offender youth from our agency out to either TJJD parole, TDCJ parole, return to court for required hearings at 19, or return to court for early transfer hearings.
And as part of your duties, do you create what's called or compile what's called a master file?
Yes, for the court.
Okay. And did you have a master file compiled for the court in reference to Gerard Coleman?
Yes,
Okay. And you provided that to the court and the parties, correct?
I believe my staff did, yes.
And is Mr. Coleman currently on the Zoom hearing that you're able to see?
Yes.
Could you please identify an article of clothing that he's wearing and what the moniker or name is on the Zoom window that he's got?
He is in an orange and white striped uniform, and it says I Gunter.
Judge, I ask that the record reflect this witness has identified the respondent.
So reflect.
And Judge, at this time, I would like to offer Petitioner's Exhibit 1, which is a CD that contains the master file, and 1A for the record only, which is the sleeve. I provided that to the court, and I previously tendered that to defense counsel for inspection.
No objection.
Objections to 1 or 1A?
No, Your Honor.
All right, so 1 and 1A are admitted.
Ms. Coy, does TJJD make a recommendation to the court as to if a child should be paroled or transferred to the Texas Department of Corrections?
Yes.
Sorry, I think I said the title wrong. What's the adult prison system that?
Well, it's the Correctional Institutions Division of TDCJ.
And TJJD makes a recommendation as to Mr. Coleman, correct?
Yes.
What is that recommendation?
TJJD is recommending that Gerard be transferred to the Correctional Institutions Division of TDCJ.
And the basis for that recommendation would be contained in that master file that the court's been provided, correct?
Yes.
I pass the witness, Judge.
Cross-examination. Ms. Herrick, I think you're on mute.
Thank you. Ms. Coy, when was the recommendation made? And when was the file completed and the recommendation made that he be transferred to the Correctional Institutional Division?
The file was made and submitted on August 1st of 2014, or of 2024, sorry. And the original request for transfer, let me see, was made June 18th of 2024.
At that time, was it known to TJJD that Mr. Coleman had some outstanding charges pending,
Yes,
specifically federal charges and some county charges?
correct.
At the time the recommendation was made, was it known what or if the punishment would be on those federal and county charges?
No, it was not.
Your Honor, I'll pass the witness.
Redirect.
Nothing further, Judge.
So just to clarify, Ms. Coy, the original offense was Mr. Coleman was, I guess, him and some others had set up a drug deal and then ended up shooting the dealers. Is that correct?
Yes.
And do you know how many people were injured?
I know for sure there were, I believe, at least 2.
And this occurred outside a gentleman's club, is that correct?
Yes,
And according to your report, he fired indiscriminately into a crowd.
yes,
And then subsequently, TJJD paroled him, is that correct?
correct.
Okay, and how did he do on parole?
He was out on parole. He appeared to be following rules, working. And then it came to light that he was arrested and had received adult deferred adjudication for an offense, and then he was revoked for failure to report an offense to his parole officer and an arrest.
I'm sorry, when you say failure to report, you mean failed to show up to his parole officer or failed to report the offense?
Failed to report that he was arrested to his parole officer, which is a requirement of his parole.
What happened to his parole at that point?
It was revoked, and he was to be sent back for an extension of his stay with us.
So I do have a question. So this type of offense, the aggravated assault with a deadly weapon, that's a 2-year minimum period of confinement, correct?
Yes.
So what happens? So obviously he finished the 2 years, then he was paroled, and his parole was revoked. I've always been curious, does that mean he starts a new MPC, minimum period of confinement, or is he just revoked and then y'all would parole him again if it was appropriate? Is there a minimum period of time or just simply what TJJD feels is more appropriate?
So there are minimums, and they're assigned based on what the actual revocation offense is. They're 3 months, 6 months, 9 months, depending on what the offense is. He received a 3-month stay, minimum length of stay based on his revocation.
And what was the offenses that he was arrested for?
He was arrested for assault family violence, which we did not know about, and received adult deferred probation for that assault, and that was in February. And then he was arrested April 17th, I believe, for the federal offense.
What was that offense?
That was the theft and possession of a USPS mail key.
So simple theft?
No, it's theft in the possession of the key. It's a federal offense for the stealing of the mail key, arrow key, whatever. I'm not sure what that is, but.
Because I was reading a report and I felt like there was an armed robbery of a postal carrier. Am I missing something?
That's what I'm discussing. Yes, that's what I've.
Okay, so that also did involve a firearm.
Yes, I believe so. Yes.
And did we confirm, I know in your report you said the family violence was on his pregnant girlfriend. Was that confirmed that she was pregnant? Or is that just kind of in the report that you received?
That was in the report that I received.
What was Gerard's highest stage level while at TJJD?
He earned stage yes.
Okay, and is that before he was paroled or after his parole was revoked? How high did he get back up? Or did he ever come back to TJJD?
He never came back. He's been in federal custody this entire time.
So how many months of his original 10-year sentence has he completed?
He has completed a total of 45 months of his 10-year sentence.
But for him to be paroled, he completed the capital and violent offender program. Is that correct?
Yes, sir.
So all the programs that TJJD normally has for an aggravated assault deadly weapon, all the assessments that you did as far as substance abuse, anger management, all the behavioral problems, he already completed all those successfully. Is that correct?
Correct.
And then even though he was paroled, he was then subsequently arrested for the armed robbery of a postal carrier.
Correct.
So typically, what does TJJ do when a youth completes all the programs, is paroled, and is re-referred on another violent offense? Like, how do y'all decide what treatment a child would need? I know Mr. Coleman never had the opportunity, but I'm just curious, what would TJJD do in those situations?
So generally, what happens is a youth would be returned to the facility. They would be reviewed by treatment to see if there were what treatment programs would be available. But just simply based on the revocation of their parole, we would also require a request a hearing to transfer over to TDCJ based on the parole revocation.
So typically, and not, I know every situation is different, but typically if this type of situation where it's an aggravated assault with a deadly, or multiple counts of aggravated assault with a deadly weapon, and then a new adult offense involving a weapon, y'all would just, I mean, TJJ's kind of stance on this one is you would just refer for an early transfer of parole hearing. Is that correct?
Yes.
Okay, that's the questions I had for Ms. Coy, but traditionally I open it back up. Mr. Sorrells, if you had follow-up questions that I may have triggered anything.
I have no follow-up questions, Judge.
Ms. Herrick, I want to give you the opportunity as well.
Thank you, Your Honor. Ms. Coy, in your review of Mr. Coleman's file, would you agree that during the time that he was at TJJD, when he was away from family, and during the time when he was on parole, he typically does well when he is not, I guess, living with or staying with or in the custody of his mother, but he keeps going back to her, and that's when he has problems again?
I can't say that one way or another. I can tell you that he did not have a lot of incidents while he was in our facility. But I mean, his behavior is ultimately his behavior.
And I don't disagree with you. I'm just, trying to connect the dots, right? Now when he was when his parole was revoked and he was ordered back to TJJD, his minimum length of stay, you said, was 3 months. Is it true that that was ordered in May of 2024, meaning his minimum length of stay would have expired in August of 2024?
Yes.
I'll pass witness.
So Ms. Herrick actually had a good question that made me think. So when he was he paroled to his mother's home?
I believe he was.
Ms. Coy, I'm going to ask you to stop for a second. This is one of the frustrations with Zoom. Mrs. Simpson, you are in court right now. Please don't lay on the couch. If you want to participate, I'm happy that you're here, but your face needs to be on camera. This is still court. You still need to show respect for the court. Okay, thank you. All right, Ms. Coy, you were saying.
Was checking. I believe he was released to his mother.
All right, thank you. All right, Mr. Sorrells?
Nothing further, Judge.
Okay, Ms. Herrick, any last questions?
Yeah.
I'm sorry, I didn't hear you.
No, Your Honor.
Oh, okay. All right, thank you. Mr. Sorrells, your next witness.
At this time, Judge, the state rests.
Okay, thank you. Ms. Herrick, your first witness.
Yes, Your Honor. I'll call Pia Letterman.
All right. Ms. Letterman? Good morning still. If you could raise your right hand, please. Do you solemnly swear the testimony you're about to give at this cause currently trial, you will tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you. Ms. Herrick, please proceed.
Yes, Ms. Letterman, did you represent Mr. Coleman for the federal charges that he had?
I did. I was appointed to represent him. I can tell you the exact date. April 19th.
Of 2024?
I'm sorry, 2024.
You represented him consistently since then, correct?
That is correct.
Okay.
And in federal court, he still is my client till one of us says otherwise.
Is it true that he pled true to the federal court charges?
So we didn't plead true, but we did accept responsibility and not go to trial on the federal charges.
Thank you for correcting my language. And so he accepted responsibility and then was set for sentencing hearing, correct?
That is correct.
And did you represent him at that sentencing hearing?
I did.
And do you have that case number for the record?
I do. His federal court case number is 4:24-CR-00149-P-1.
Do you have some documents here with you that pertain to his federal sentencing?
I do. I have I created defense exhibit number 1, which is his entire docket, the judgment and sentence of the court, as well as the I could not include for you the statement of reasons, but I did include the judgment and sentence, as well as his terms of supervised release.
And I can't remember who just said this, but it also includes all the docket entries, correct?
Correct.
Okay. That's been marked as defendant's exhibit number 1 and provided to the state, and also a copy has been provided to the court. We move to admit that exhibit at this time.
Charles, any objections?
No objection, Judge.
All right, the document titled Defendants 1 is admitted.
Thank you, Judge. Before the sentencing hearing, were any documents or was anything prepared?
Yes, in federal court, before a sentencing, there is what's called it's called a sentencing report, a PSR, a pre-sentence report. So we have to sit down and we get interviewed with client as well as probation, the federal probation officer, and they prepare a federal pre-sentence investigation report, which is submitted to the court for the court's consideration at sentencing.
There's probably a lot of information that you learned about Mr. Coleman from that process. Would you agree?
There is a lot of information prepared in the pre-sentence report.
Okay. To kind of skip back to a question that we just asked Ms. Coy, is it your understanding through all the history and all the information that you've learned about Mr. Coleman that when he is either, in custody, but also even when he was on parole, but not living with or in the custody of his mother, that he does remarkably well and is able to follow the rules? But on the other hand, when he is in the custody of his mother, he's repeatedly had trouble.
That is correct. And I spoke to Mr. Coleman multiple times. I reviewed his entire juvenile file. I think we received almost 3,000 pages between juvenile and the TJJD files and the pre-sentence report. There's no offense to mom, but at 11, 12, 13, 14, it's nothing but mom failing to engage in services and Mr. Coleman getting kicked out of juvenile services because mom refuses to show up to detention hearings. Mom won't show up for meetings with probation. Mom won't take him to counseling or therapy or classes. I did notice also in his file, he was sent to placement and he did extremely well in placement. He was released from placement early and we rewarded him by sending him back to mom, which just, once again, mom was reason to believe for neglectful supervision. Mom was reason to believe for abuse and neglect. And we sent him at the age of 13 back to mom. Then we see again in his entire juvenile file, mom not engaging in services and mom not being with him. He went back to juvenile where again, nothing occurred until ultimately he ended up at TJJD. And I believe in the TJJD file, I also saw mom failing to engage in services. And I don't think mom ever visited him or engaged in any therapy or counseling. So when he gets out, he does well for a while. But then again, we're neglected by mom and left to our own devices.
That's certainly, I'm sure, something that was emphasized at his federal sentencing hearing. What did the federal court also take into account Mr. Coleman's juvenile history and everything that he has?
He did. So the federal guidelines have amended and they have a specific section for juvenile offenders. Judge Pittman summarily rejected that and said he did not agree with the sentencing guidelines or with the youthful offender guidelines. Judge Pittman did state on the record that he was taking into consideration Mr. Coleman's entire juvenile history at sentencing and dismissed the sentencing guidelines amendment, which went into effect Monday.
Tell the court what the sentence ended up being on his federal cases.
Sure, and if I can refer the court to the document, exhibit number 1, and if you look at docket entry 61, it's the synopsis of the sentence. Not only did he reject our juvenile and our history, he then sentenced him to 60 months on count 1 and 91 months on count 2, and he ran those concurrent. So Mr. Coleman will have to do 151 months in the Federal Bureau of Prisons.
You said concurrent, but you meant consecutive.
I'm sorry, consecutive.
So his 2 federal sentences are to run consecutive, correct?
That is correct.
Do you know how the Bureau of Prisons will take into account any sentence that Mr. Coleman's given in this case for the TJJD time?
By statute, and I can point you to the statute, I just don't have it with me. Judge Pittman specifically ordered that the sentences would run consecutive to any state or local charges. So because he's in the BOP, well, if he was writted to state court for any time, he would not be getting credit on his federal sentence.
Do you know if this court is bound by a similar rule?
No, like Judge Pittman, this court is not bound by another court's order. This court can do whatever it decides with concurrent or consecutive.
So this court could order any sentence that's imposed today to run concurrent with the federal
That is correct.
sentence. Okay. Is Mr. Coleman currently in the custody of the Bureau of Prisons?
He is. He's not on writ.
Why is that relevant?
Again, because he's not on a writ, then he is getting federal credit for this time. However, then it's up to Judge Kim to decide if he would also be getting state credit or just stay on probation.
In the federal sentencing hearing, was the safety of the community taken into consideration by Judge Pittman?
It was, if you look at the judgment and sentence, and I was not able to provide a statement of reasons because that was sealed, but the judgment of Judge Pittman under the federal guidelines 3223A, it does consider safety of the community, safety of the client as well. So those were considered and they are in the statement of reasons.
And those were specifically considered, right? Not just generally, like the judge indicated that he specifically took those things into consideration?
Correct. Under 3223A, like any sentence, it has to be an individual sentence per person.
Does the federal prison have parole as a possibility?
Yeah, federal court does not do parole.
Okay. Does that mean that he will complete the entire 151 months that he was sentenced to?
He may be eligible up to the Bureau of Prisons if he's receiving any good conduct time off of that, but there's no parole.
Did you review Mr. Coleman's United States probation sentencing report?
We did, and I reviewed those with Mr. Coleman as well.
Okay, and did that indicate that the protection of the victims was also taken into consideration by Judge Pittman?
There was, as part of the sentencing, and probation sends out letters, just like juvenile does. We did not, we received one letter that was rejected by the court because it was a vague check marks. We didn't have a name. We don't know who it went to. And they just said, you know, my retirement has been affected, but they didn't really give us, we didn't even have a name or anything. So we all pretty much ignored it. We received no other documents from any alleged victim. We received nothing.
So in addition to the federal charges that we're discussing, there also was the state charges that he had here in Tarrant County that were pending, correct?
That is correct.
he was arrested for a couple of misdemeanors, assault on a family member, violation of a protective order, and interference with emergency call. Is that your understanding?
That is correct.
And then he was also arrested for an unlawful use of a motor vehicle. Is that your understanding?
That is correct.
Is it your understanding that the unlawful use of a motor vehicle was dismissed?
That is correct.
And so he only had or has misdemeanor state charges pending.
That is correct. And I actually spoke to girlfriend about the car and about the violation of the protective order. And so like most of our cases, they were back together, not realizing the protective order was still in place. And I did speak to Mr. Coleman at length about it as well.
And so is it your understanding that the alleged victim of the assault on a family member is still Mr. Coleman's girlfriend? They're
That is
still together?
correct. And she did appear at sentencing as well.
Okay. She is pregnant now, or maybe just recently had her baby. Is that true?
That is my understanding, yes.
Is it your understanding that she was or was not pregnant at the time of the alleged assault on a family member?
I'm not good at math, and I promise this court not to lie, so I don't know.
Fair enough. Did the federal court take into account these pending state charges as well?
They did. Judge Pittman specifically referenced them again in line 61 of the docketing sentence. He ordered that they all run consecutive to his federal case. They are also mentioned in the pre-sentence investigation report, which was prepared by probation, and they were taken into consideration in the sentencing guidelines.
How do the guidelines work?
So in federal court, you have a guideline where you get credit for your criminal history as well as your criminal offense. And because of those federal charges, Mr. Coleman did get points on his criminal history, which is what led to the higher offense, because we got criminal history points. They were just mentioned, and then we also got status points for them. So all of his juvenile history, most of his juvenile history, and then his adult history got him criminal history points.
So you're saying
What are status points?
So, excuse me, Judge, sorry. So under the federal guidelines, which again, I'm so sorry, Judge, I did not bring my guidelines book. Actually, it is. It's in my briefcase. If you would go grab my briefcase. So you get points for your criminal history. Sometimes they're 3 points, sometimes they're 2 points, sometimes they're 1 point. And that is your criminal history points. So it's a graph. So the x-axis is your criminal history points. He did get points for the term that he was on TJJD for. That was a 3 point on his criminal history. We got 1 point each for the misdemeanors. He had 5 points. And now in federal court, if you have more than 7 criminal history points, it's better for clients now. You get another point just for being that high on your criminal history. But he did not get the last point because I believe our criminal history, he did get the criminal history points, and we ended up with 5 criminal history points. 2 for the juvenile, 1 for the assault, and then 1 for the violation protective order. So with a 4 points, he ended up a level 3. And so what that means is on any offense level, we automatically go out 3 columns on our for punishment.
So it's just a matrix type of situation.
Right. And so his matrix so the highest is a level 6 because of those 2 other cases, those pending charges. He became a criminal history category 3 with 4 points. So it really affected the guidelines quite a bit.
So are you saying, oh, sorry.
It's clear as mud. I mean, I can, if you want to admit things of it. It's a tricky matrix, yes. So you go criminal history points this way, and then offense up and down this way. And then where the 2 meet is where your guidelines are. The table, yes.
Ms. Herrick, please continue.
Thank you, Judge. So, long story short, are you saying that Mr. Coleman's federal sentence was already made higher because of his juvenile and state criminal history?
Quite a bit higher,
Okay,
yes.
okay. Now we just heard Ms. Coy testify, and I am probably going to get this number wrong, but is it your recollection that she just testified that Mr. Coleman has around 45 months of credit at TJJD?
That is correct.
Okay, which would mean that he would have 75 months left. Is that right? Math?
If my math is correct, yes, 75 months.
Is that less than the 151 months that he was ordered to do in the federal prison?
Quite a bit less, yes.
Okay. Does Mr. Coleman have services that he will be required to complete once he's released from federal prison?
Yes, as part of the sentencing paperwork we submitted, the last page talks about supervised release, and he has 4 pages of supervised release conditions.
What are some of those conditions?
He's got to report no new offenses.
Slow down, please.
I'm sorry, he has to report within 72 hours, work full-time. He has to not commit any new offenses. He cannot consume any illegal narcotics. He cannot consume alcohol. And with some of the requests that we asked for, or that he be provided treatment for mental health treatment, as well as drug and alcohol, and just in case he needs those. And we did ask that he go to a licensed therapist, and that's just some of his conditions.
And so that sounds a lot like what we know parole to be like. What is supervised release?
Again, in federal court, we don't do parole, but we do quote unquote supervised release, which it's a lot like parole. If you violate, you end up back in the Bureau of Prisons, much like parole revocation. And the same, if you don't complete the conditions, you go back to the Bureau of Prisons for violating your supervised release.
If he were to violate the conditions of his supervised release, how long could he have to go back to the federal prison?
I haven't calculated his supervised release, but it could be anywhere for up to 3 years.
Okay.
Depending on the violation.
Okay. Now, you have been representing Mr. Coleman, of course, while he was awaiting the federal sentencing, and during that time, was he held at the Johnson County Jail?
He was.
Okay. Did Mr. Coleman take advantage of some opportunities to complete some classes and programs while he's been in the Johnson County Jail?
He did, quite a few.
What classes and programs has he completed?
He did a 1-hour anger management. And again, all these classes are on the computer because they don't actually have services in Johnson County. He did a parenting class. He did anger management. He started his CDL. He started his welding certificate. I want to say there was almost 8 or 9 certificates that are on my phone, but I can't get them to print. But he had done quite a bit.
And he did those of his own accord, is that correct?
That's correct. He and I had not talked about that, and I wasn't even aware that Johnson County had those on their tablet.
What is Mr. Coleman's plan for his life once he is eventually released from custody?
We did that also as part of the sentencing and the presentation we gave to Judge Pittman. We've spent a lot of hours together. He is going to do a lot of therapy, a lot of counseling, even when he's released. He wants to do CDL and always, so he can work for himself. He can be a truck driver. He can get into welding. The Bureau of Prisons has several programs. So that way, when he is released, he can have employment, immediate employment, and he won't have to then go to a class or go to counseling. He can be immediately employed as an electrician, a welder with his CDL. Our main goal was not to go back to mom or that neighborhood. He would then be old enough to be out on his own and not rely on mom for services or for anything else.
Is it your opinion that his goals are reasonable and achievable?
Absolutely. With good support, he's always done really well.
I'll pass the witness.
Mr. Sorrells?
Sorry, I have no questions for this witness, Judge.
All right, thank you. Ms. Herrick, your next witness?
Your Honor, will rest.
Okay. Mr. Sorrells, rebuttal.
Rest and close, Judge.
So closing arguments.
Judge, I would ask that the court follow the recommendation of the Texas Juvenile Justice Department in transferring him to the institutional division of the Texas Department of Criminal Justice. I believe Ms. Letterman actually said it quite well when she said that Judge Pittman of the federal court took into account the safety of the community and the protection of the victims when he decided and determined that it would be appropriate for this respondent to have consecutive sentences, and not only consecutive sentences for the 2 counts that he had in the federal system, but Judge Pittman also definitively puts in his order that it would be subject to your sentence also, and the federal sentences would be consecutive to it. I believe he has a lot of the information that this court also has, and he has made that determination. I just ask that this court adopt that same mentality and transfer the respondent to the adult prison system and issue a writ in order for his sentences to be consecutive, as the federal judge has indicated in his order. Although this court is not bound by it, as Ms. Letterman did say, this court does get to make its own determination as to consecutive versus concurrent. I am urging the court that consecutive would be appropriate. Thank you, Judge.
Thank you. Ms. Herrick?
Yes, Your Honor. The recommendation of TJJD that Mr. Coleman be transferred to the institutional division of the Texas Criminal Justice Department was made prior to his federal sentencing, meaning they made that recommendation without knowing that he would be sentenced to 151 months in the federal prison. Judge Pittman did take into account this case as well as any other pending unresolved matters that Mr. Coleman has. It's mandatory that the Bureau of Prisons not run concurrent with state sentences, so that's by law. And this court has the discretion whether to run the sentences consecutive or concurrent. If his sentence here runs concurrent with the federal sentence, he will be at minimum 29 years old when he's released from the Bureau of Prisons. That is certainly old enough for him to be able to live on his own and maintain his independence and stay away from the negative influences of his family. As we noted, he has a reasonable and achievable plan for his future when he's released. He has already taken steps that were required of him by no one to get certified in different vocational skills. He's making steps to obtain his commercial driver's license. He's taken a parenting class knowing he has a baby on the way, taken an anger management class. Again, those were not ordered by anyone. He did those because he wanted to. Mr. Coleman, he accepts responsibility for how he has gotten to where he is now, and he's been sentenced for that accordingly by the federal prison. We ask that this court not transfer him to the institutional division, but if this court is inclined to transfer him to the institutional division, we ask that this court run his sentence there concurrently with his federal sentence. Thank you.
I have a question, and I guess I have a question your math. So he has a 151-month federal sentence. That I calculate that to be about 12 and a half years. He's 19 now. That sentence just started October 30th. So what am I missing?
He has some credit. Oh,
No.
just kidding.
He will only get federal
Ms.
credit.
Lederman, I can't let you. Sorry,
Yeah,
but
so-
you're welcome to advise Ms. Herrick.
1910, so he might be older, 31.
It appears that
My math
the
was wrong.
respondent's counsel is not
Math.
proficient in math. He'll be about 30 or 31.
So it's about 12.5 year sentence.
Yep.
He has some credit in, but he's probably looking around 31 at this point. Is that correct?
Judge, sorry.
Okay. All right. No, I want to clarify. So I interrupted you. If you want to go back to you were talking about the classes.
No, I finished my argument, Judge.
So this court having considered all the competent evidence, this court having considered the experiences and character of the person before and after commitment to the Texas Juvenile Justice Department, having considered the nature of the penal offense that the person was found to have committed and the manner in which the offense was committed, having considered the abilities of the person to contribute to society, having considered the protection of the victim of the offense or any member of the victim's family, having considered the recommendations of the Texas Juvenile Justice Department, County Juvenile Board, local juvenile probation department, and prosecuting attorney, having considered the best interests of the person, and finally, having considered any other factor relevant to the issue to be decided, will return the person to the Texas Juvenile Justice Department. Return the person to the custody of the Texas Juvenile Justice Department without approval for release of the person under supervision. Mr. Coleman, I am transferring you to TDC to complete the remainder of your sentence. However, I am going to run this concurrent with your federal sentence. Mr. Coleman, I'm breaking this up into two different categories. I look at the original offense where you at 15 years old, you were inside a gentleman's club and there was a conflict and you fired indiscriminately to the crowd, hitting two people, right? That was the offense that you were originally sent to TJJD for. I also look at you while you're on parole, that now you are convicted for an armed robbery with a firearm or a gunpoint robbery of a postal worker for the master key, right? Now you have that issue with the federal courts, with Judge Pittman. I highly respect Judge Pittman, and I agree with him a remarkable amount of the time. However, in my discretion, I do try and keep juvenile matters separate from adult matters. I do not feel like an extra 3.5 years in the state prison after you finish your federal sentence will do anything to protect our community more. It would simply be punishment. As a society in the state of Texas, we do not punish juveniles for their juvenile behavior. We rehabilitate them. So if I'm taking the punishment equation out, and my concept or my guiding light right now is simply protecting our community, I do believe after you finish your 12-year sentence with the Federal Bureau of Prisons that I hopefully are mature enough at that point to learn from your mistakes and no longer be a threat to our community. So I do believe the 12-year sentence is appropriate to protect our community. All right, so at the end of this, in the conclusion, I do order you remanded or remain in the custody of the Federal Bureau of Prisons for you to complete your sentence there. They will be transporting you shortly for wherever they decide to place you. Now, because there was no agreement, you do have a right to appeal. I do have a document here. You will have a yellow copy. Your attorney does have a duty of mailing that to you at your last known address, but that explains that right to your writing. If you choose to appeal my decision, you may do so by filing a notice of appeal with the Second Court of Appeals located in Fort Worth, Texas. Ms. Herrick, you do have a duty to prosecute that appeal if you so desires. He probably does not want to appeal my decision today. All right. So, but anyways, you do have that right. Anything further for this hearing, Mr. Sorrells?
No, Judge.
Ms. Herrick?
No, Your Honor.
Okay, that shall be the order of the court. Mr. Coleman, I hope you learn from your poor decisions and make better decisions in the future. Okay, I wish you the best of luck. Ms. Coy, thank you for being here. All right. All right, that concludes this hearing. Thank you, everyone.
Thank you, Judge.
Oh.